My presentation, or it's more of a conversation, is about the challenge of interweaving legal history into the online teaching of EU law. Just struggling to get the slide to move on for some reason. So I would sort of characterize EU legal history, with all apologies to Simon Scheimer, as the history of now. So just to give you the idea, the module has been going for 5 or 6 years now, and it's part of the Open University Level 3 modules. It's a 30 credit modules with 300 hours study, and it's taught from October to May, and it's compulsory for LLB and joint degree students, and it also could be taken as part of the LLM, and it's assessed by tutor marked assignments, and at the end of the module, a extended module assessment which requires research, and students take the module either part-time or full-time. So when the module was first sort of conceived as an online teaching platform, it had certain objectives. So I'm going to share some of those objectives to you. Why we decided to have a top-down approach on teaching EU law. By top-down, I mean teaching EU law from the perspective of the EU institutions and its law. So I'm going to touch on how the module explores EU legal history through a focus on primary sources of law, which has diversified the curriculum in a way that most textbooks probably do not do. So to do that, the module engaged students in different ways than the traditional ways. It focused on their listening to presentations or audios from lawmakers, enforcers of EU law, and interpreters of EU law, and by engaging into research of primary sources of EU law rather than textbooks. And why was this decided? Well, the problem with teaching history of EU law is there's really no antecedents, such as there are in many other courses of legal systems. You can talk about perhaps the Hanseatic League, but that was a union of guilds and cities in Europe. So there was no sort of historical perspective or continuity that could be brought into EU law. It started, as we all know, in the 1950s at the end of the Second World War. So the other issue we had in constructing the course was that there was a lot of stereotypical publications in the media. This image of the EU of being white, elderly gentlemen, the image of the EU being them and us, that the EU was imposing its will on the various member states. The other issues involved in teaching EU law is this sort of underlying, almost immutable architecture of EU law, which is that sovereign states are immutable. And in reality, historically, the existing sovereign states of the EU, or member states, have sort of frozen the boundaries of Europe. It's an assumption made from about 1870 on. So those were some of the challenges in teaching EU law. Now let's look more at how we tried to overcome them. So the first was in order to bust these images or overcome these challenges, was to focus the teaching of EU law on what I call primary sources. So the conception was, of course, that the EU, and when I talk about the EU, I mean it's EEC as well. was that it was just an economic union. But if you look at the preamble of the treaty, and students are directed towards this, it also has social objectives in relation to improving the living and working conditions and the need to of the citizens of the EU, and the need to ensure peace, liberty, and create solidarity within Europe. So the module structure was divided into blocks, and the early blocks of the module were to look at the EU in context, and that was a step-by-step introduction to EU law terminology, because remember, for students coming from common law tradition, they're studying what is essentially or mainly a civil law type of legal system. And so it's important they understood how terms were used in the EU's legal system. The second unit in that block was to provide with historic context to the EU, starting with the Second World War. And that was more of a traditional unit. And then the third unit in that first block covered the mechanics, the essential principles and mechanisms underlying the EU treaties, the principles including non-discrimination, legislative process, and foreign affairs, etc. I can see time's going quickly, so I'll jump to the last block, which was the European Union law in close-up. And we took two topic areas in looking at the European Union law in close-up. We explored in Unit 9 environmental law, which is looking to the future and developing EU law from the perspective of the EU's obligations internationally and its obligations to the world at large, we'll say, in terms of protecting the environment. And we looked at the last unit being a unit on competition law and the protection of consumer rights, we'll say, in regard to competition. So students had early on a mission statement, and I'm putting it up on screen now. This module uses primary sources of law and views from a range of people talking about aspects of EU law. The hope is to attune you, that's the student, to EU terminology. Why listen to voices of different people? To give you, the student that is, a flavour of the perspectives of the key movers in EU law. Why use primary sources? Because EU law resides in its treaties, legislations, and case law, not in learned or academic commentary or any social media, of course. Therefore, at various points, the students were given activities from which to derive their answers by reading the treaties, EU legislation, and the jurisprudence of the Court of Justice of the EU. So students from early on knew that's what was expected of them. There was some looking in history. In the Unit 2 of the unit, it looked at the fact that the idea of Europe is very old. Unit 1, Simon, it's all right if I go on for a few more minutes?
Yeah, you're fine, Edwin, please do.
Yep. So Unit 1, it puts the EU law in context. Its focus is not on how the EU law applies in a particular member state, but on the legal bases of EU competences and EU substantive law arising from those competences. Those were the competences when member states, as the Mirror puts it, surrendered some of their sovereignty. So the unit focused, as I said, it has an oral tradition of listening to the opinions of people that were actually involved in creating the EU. So it focuses a lot on what the founding fathers of the EU said. And the students were given an activity to listen to short speeches by the founding fathers so that they could understand their perception of what the EU, why it was being created, and what it ought to be. On the screen now is a list of the speeches that they listened to, and it ended with a talk by Vladimir Drobnik, who was gave the perspective of a member state joining the EU, the the Croatian member state. The module also has what I'll call an oral thread through it. There's a conversation with one of the recently retired judges of the Court of Justice of the European Union. And from time to time, students will dip into conversations with Sir Nicholas and understand why different aspects of EU law developed and where they might be going to and issues going forward, such as joining the EU and leaving the EU and the legal issues involved with that. The students are given a sort of a reflective task in which they ask themselves, has the EU failed? Has it stopped wars? Is wealth being shared and distributed fairly? Or is it polarizing between North and South, rich and poor, and we could say East and West? And how have the founding ideals developed? And why have we ended up with some that are quite different? So an example of using sources of EU law, and Vergent and Loos, one of the early cases of the Court of Justice, as it was then called, it explained that the EU was a new legal order. So in order to establish a student's understanding of why it's a new legal order, in activities are given, asked to find, read, and try and understand why the court considered it a new legal order and why it was necessary to have a new legal order, given the objective of the EU in those days was a level economic playing field. Also looks at some comparative legal history. For example, compares in relation to competition law, the approach in Europe, which is the protection of the consumer, as opposed to the United States, where it's the protection of one enterprise from being dominated by another. Moving on, so the treatment of the environment, this is more looking the aspiration of EU law going forward. There's a unit on the European and the environment and the European Union law's attempts to comply with a neutral carbon imprint by 2050. So to understand that, the students focus on Regulation 2021 of number 111.9 of the European Parliament and Council, which sets out that objective, and students study that primary source to see how the objective needs to be attained going forward. In competition law, that's the last unit of the course, students look at how competition law works, its purpose, and at the end of that unit, the students are introduced to the new gatekeepers, looking at law going forward. And they consider the Microsoft case and the Google case that the European Union has against those two gatekeepers. And students are asked to think about how those gatekeepers can control our legal futures going forward. It ends, well, going through the module is sort of the legal history of tomorrow. And the focus there is on the issues that are involved in a member state leaving the European Union, what legal issues arise, sort of legacy issues for trying to retain EU law if it's necessary, and issues that may exist between the member states of the European Union going forward.